Stephen wants to know whether you think that Section 2 of the Voting Rights Act is about to be obliterated. We've seen it chipped away and chipped away by this Roberts Court already.
Yeah, so that's a very good question that relates to the Louisiana case that was heard last week. And my tentative answer is um, they're not going to flat out overturn Section 2 of the Voting Rights Act, which is the section that requires that when there's a minority group that is defined and cohesive enough to theoretically elect a representative of its choice, it has to be given that opportunity. What I think they're going to do is keep Section 2 alive, but cut the heart out under it and in a way, weaponize it. And what I mean by that, the argument took, to my way of thinking, maybe I just wasn't prepared enough, but I was very surprised to the point of being shocked at the turn the argument took, which had to do with politics. And so what the lawyers arguing for the Trump administration and for the state of Louisiana were saying is, okay, a few years ago, the court ruled in a case called Rucho that gerrymandering for political purposes was outside the jurisdiction of the federal courts, that the court wasn't going to get into it. It just was a thing. And the courts could not have a kind of a metric to be able to ascertain how much political gerrymandering is too much. And so we're just not going to get into it. Okay, that was a case about the jurisdiction of the federal courts. Now, that case, Rucho, R-U-C-H-O, is being used in the Section 2 voting rights area to say, okay, if you're gerrymandering for politics, that trumps, I hate to use that word as a verb, but that trumps the racial considerations, that trumps the racial equality that is demanded by the Voting Rights Act.